Court does call the case of Haverville on Clark versus Jeffrey Thompson.
Good morning, Your Honor. J. Baig, P36820 on behalf of plaintiff.
Good morning, Judge Simpson. It's Jeff Thompson.
All right, you can take.
Oh, sorry.
All right, well.
Oh, sorry. Oh,
Well, we had a hearing maybe a week or so ago, and you instructed Mr. Thompson to file an answer by the 26th of last month.
I think I gave him to. Well, hold on. Yes, I did. Right, you're right.
He said he filed it. I checked with the clerk here, and it may not have been received by the court. He said that he mailed a copy to plaintiff's counsel. In any event, I had him email me a copy, maybe about half. I'm in a copy of his.
unfortunately, Judge Simpson, the court doesn't even have the representing attorney's email on file. There's no website online that we can get the email from. The telephone number that we call with my CMH case managers is just a generic telephone number with no idea whether or not it's a law firm or not. The information was sent electronically. We called the court to make sure that it was.
Well, hold it. You received paperwork at the beginning of this case.
What do you mean?
Well, you received the complaint, right?
Yes.
And the, if I'm not mistaken, counsel, the complaint has your. The complaint has all of counsel's information.
Yeah, it's not. The information was sent to his office. The girls, I just checked with the clerk's office. It was received on Wednesday. They said that they're going to walk down a copy today.
I'm not going to make an issue about the answer. I mean, he
Yeah, it just
provided
came
an
in
answer.
this morning. Do you have
This
a
morning.
copy?
Yes, exactly.
You do. Do you have a copy?
I do have. Yeah,
Okay.
I had a meeting.
All right. Let me just see this because I have not.
Settlement is not likely. I believe this is going to go to trial, so I think we're going to set some dates.
All right. What primarily is the issue in this case, Mr. Counsel, from your standpoint?
I had psychological challenges, which I just recently went inpatient for.
Pardon?
Know about some mental health issues, and it just recently been taken care of. We started a whole new medical regimen that we're slowly going to tweak them over time. I've got 2 different psychiatrists that are following me. 2 of them. I'm now involved with case management and with CMH, which has all been really helpful. It's just there was a lot going on at the time. My dad just died a couple days before the event, and my mom's in a nursing home right now. So I mean, there's a lot, and I know that that's ancillary to this case, but it's affected me in a lot of different ways that I never thought possible. It's really brought up a lot of the behavioral health and mental health issues. So I've got a grasp of them. I'm doing well. I've never bothered anybody at the apartment complex. I love my neighbors. They love me. And I thought I had a great relationship with the staff there because they're always really nice to me. I wouldn't have a reason to think otherwise. I mean, I don't want to lose my home, and I'm feeling a lot better now. It's really hard, you know? So even standing here right now, I get nervous when I'm in here. I'm nervous in front of you, and this guy makes me nervous. It's just a long time ago, I couldn't tell you. I just run the opposite direction.
And so in terms of the specific behavior, is your client open to any type of probationary agreement?
I was thinking about that. I don't believe so. They're pretty adamant about terminating the lease. There were two incidents, as noted in the notice to quit, which is part of the file. I won't get into the details here, but it's
I was
in-
sick,
in-
Your Honor, I'm sorry.
Yeah.
I gladly admit where I'm wrong. I know,
Pardon?
I know where I'm wrong. I didn't know what I was doing at the time, and with the person I was dating, and I'm sick. I'm doing what I need to do now to get the help that I need, and it's really intimidating to even be up here right now. So, and it seems like it's every couple weeks that I have to come back, and I know it's a process, and I know that
Right, but I guess what I'm, do you have, I mean, have you tried to provide or provided any type of medical documentation, even for plaintiff's consideration in this?
Yeah, I tried to, and we tried because it said in that first notice that they were trying to talk to me within the first 10 days. And Latasha, the property manager, was really nice. She tried to work with me to get that, but I guess it was her manager that said no, that she didn't want to talk. Within 10 days of receiving their paperwork, she said that they had to talk to me, or they could talk to me.
Right, I get that reading. I'm
sorry.
What I'm indicating is, and if what you're telling me is not what you're telling me, then tell me that, okay?
Okay.
But as I'm understanding it, you are having mental health episodes that led to these incidents.
Yes.
Okay. I'll just ask you this. What do you have that would tell me that's the case?
They've diagnosed me with bipolar, generalized anxiety disorder, and clinical depression. I also have an autoimmune disease.
Okay, but I realize it doesn't work specifically this way. But on the dates of these particular incidents, what do you have that would tell me or anyone else that it was some type of episode, manic or other?
I'd have to get it from a psychiatrist at Michigan. I'm sure they can give you documentation of it, or let you know what happened. They can give you the documents.
Then maybe I'll ask another question.
Sorry,
No, it's okay. After each of these incidents, did you go to a healthcare professional?
yes, yeah, I was seeing a therapist and the
Yeah,
psychiatrist.
but how soon, like the incident occurs, how soon did you go?
Probably just days afterward, if it was even a day. They have the information.
And you went because
I was scared. I didn't know what was happening to me.
okay. And that occurred on both of these incidents.
I believe so. Yeah, yeah, yeah. They did.
Okay. And without getting too much into what may have been told to you, your healthcare treatment providers, they said that you were suffering from something at that point. Is that what you're telling me?
Yes.
Okay. That information, have you provided that to plaintiff at all?
No, not yet, because I didn't think we could. I'm sorry.
Pardon?
After they said they didn't want to talk to me, I didn't think they needed it, but I can give them a copy. I'm sure the doctor can even call them if they wanted to as well.
Well, that gets into a whole other complicated thing, but
Sorry.
all right. So let me ask you this. If you don't provide that, what would you be at? What are you asking the court to do?
I don't want to lose my home. I've done everything that I can over the last several years to acquire, and I came from a really bad place at Arbor One prior to that time. And
Were you
just trying to deal.
residing when? How long ago were you residing at Arbor One?
Last year, for a couple years.
And you moved from Arbor One because,
Was condemned by the state of Michigan.
yeah, okay.
I'm sorry.
So who relocated you?
It was the Section 8 vouchers.
Got it.
Yeah, maybe we set up for another settlement conference, or at least give him time to provide, counsel the, medical documentation that he's.
They can do that.
Yeah, and so remind me, how long have you been in this unit?
Since June, beginning of June. Latasha tried to get me in as quickly as she could. They were really
The
helpful.
beginning of June of this year.
Yeah.
And then this, okay. And you moved right from Arbor One into,
Yeah, because my building was really bad there.
what was your address there?
723.
Green?
Yeah.
Okay.
I just feel
It's amazing, I know.
And
Well,
next.
pardon?
I just one thing after the next. I'm sorry, I don't want to sound.
No, it's counsel, I don't know if you know anything about that whole situation.
I don't, but I think I'm getting a flavor of it, now.
Yeah, and so I'll just say it this way. He would have been one of the individuals, in particular with the address that he's given me, that was for probably an extensive period of time sitting in a condemned building.
Yeah, I had mold inside my system too. I got really sick while I was there. The doctors have that on file.
Okay.
Sorry.
And so there was just to give sort of a sketch of it, there were initially cases that were filed before me. They were removed to the circuit court.
Mhm.
The county prosecutor filed a civil claim along with the city of Ypsilanti. Thankfully, in a lot of ways, it went away from me and it was at the circuit court. There was then a federal court, and all of that is pending.
We appreciate what you did, though.
Pardon?
We really appreciate what you did. You really helped a lot of people, including myself.
Well, thank you for that, sir. I do appreciate that. So here's what I'm going to do. I'm going to set a new date, but here's what I'm going to want you to do. You got your worker's not here today, right?
No, I got to go see him after it. There's a 2-hour therapy session after this at 12:30.
Okay. So what you're going to need to do is provide medical documentation to plaintiff's counsel.
Okay.
I'm also going to want a copy to the court, but
Okay.
here's what I'm going to tell you. You tell them when they bring it to the court to put it in a sealed envelope
Okay.
and address directly to me.
Okay.
Okay, because what I don't want is I don't want, to any extent that we can avoid it, I don't want all of your medical in a court file.
Okay.
You follow me?
Yeah, I do.
All right. So how soon do you think you can get that done?
If we're on my timetable, I'll get it to you right now, but I don't know what theirs is. Maybe.
Okay.
Is that okay?
Just slow down a bit.
Okay.
Just, give you time to get it so that plaintiff's counsel can have time to consider it and the court can look at it and just try to figure it out. When's my next day?
Your next date.
Thank you. Thank you.
Okay, that's not going to be enough time.
You gotta give him more time. Yeah, more time than that.
Okay, here's what I'm going to do. I'm going to go to January 6th. I'm not going to take the December date. Okay. But so I'm going to adjourn the final settlement conference. January 6th, 2026 at 9. Okay, and how soon, so what I'm gonna do is I'm going to then require that you get it to the court, as I've said, how to do that, and also the plaintiff's counsel. What's today, the 2nd?
So he should mail it, to plaintiff's counsel. It shouldn't be, email just because of the, nature of the information.
Hard copy though.
Huh?
Oh, you maybe with the holiday, we sent a hard copy to both.
Yeah, again, I'm gonna circle the,
Send, what counsel's telling you is don't send it through email.
Oh,
Okay.
Sorry.
Get a hard copy, mail it out to plaintiff's counsel at the address that they have, okay?
Okay.
And I want you to provide that, I'm just gonna indicate by the 23rd
Okay.
of December, but if you can do it earlier and try to get it to them,
Yeah, I'll tell them
Okay.
today. Thank you.
okay, and try to get them as soon as they can mail it out so that council can go
I
through it.
understand.
Work on, okay?
Okay. Thank you,
All right.
Simpson.
Not a problem, sir. All right.
Help with
Thank you,
everyone.
Thank you, Cal. What do you say?
Thank you for all your help with everyone.
You're welcome. 2 out of 3 down. Now, something tells me everything's gonna go sideways. Court does call the case. I shouldn't say that. Jerome versus Cassidy. I have people on.
Yes.
Good morning, Your Honor. Gail Rosen appearing.
Morning.
Your Honor, Abby Cooper appearing on behalf of plaintiffs, the Drones.
Joe Lloyd, Your Honor, appearing on behalf of Mr. Cassidy.
Okay. And then Ms. Toth is here. All right.
I am appearing on behalf of Cambridge Family Holdings, plaintiff and counter defendant in this case.
All right. So I think probably the first thing that we may need to deal with is, Ms. Rosen, your motion to withdraw.
Thank you, Your Honor. I do want to make one correction. I noted in my motion that Mr. Lloyd is co-counsel for Ms. Cassidy. I learned after filing the motion that this is not correct. It was my assumption that Mr. Lloyd was representing both Eric and Paula Cassidy as he replaced Francie Novar, who's been representing both Paula and Eric. She and I were co-counsels representing Miss Cassidy. I've since learned that Mr. Lloyd is only representing Eric Cassidy. But as I stated in my did you have a question, Your Honor?
Well, no, go ahead. Go ahead.
As I stated in the motion, as Miss Cassidy is not eligible for services from our office, student legal services, we're unable to represent her. She needs to both be currently enrolled at University of Michigan and current on her tuition. We routinely check with the registrar's office to determine eligibility for our services. And since, as I indicated in my motion, she has not paid the tuition, which includes fees for student legal services since fall of 2024, she is not eligible for our services. It's my understanding that Mr. Lloyd is going to be requesting an adjournment of today's hearing or an adjournment of time to file the answer, which would provide ample time for Ms. Cassidy to hire new counsel or seek representation from Mr. Lloyd, who is already representing Mr. Cassidy in this matter. As such, I don't believe that our withdrawal will have a material adverse effect on Ms. Cassidy or her interests.
Do you have anything to say regarding the
No,
motion?
Your Honor, plaintiffs do not oppose the request.
Mr. Lloyd?
I think what she said is true. I don't have a dog in this fight either. I do not represent Paula Cassidy, as I understand it. And I think she has filed a document with the court. If you've seen it, sort of laying out what she wants to do. But I don't speak.
Who, Ms. Cassidy?
This morning, she filed a 2-page response. I filed for her, and she can't be here.
I got it. It came in, I have not. Oh,
she opposes, but she really is just asking for.
I got, thank you. Hang on. Have you not seen this, Miss Rosen? I take it?
I received it this morning, Your Honor.
And maybe you can. She says she is enrolled as a graduate student.
Tuition has not been paid, Your Honor, which includes our fees. So a student has to be both enrolled in classes
And pay, got it. Okay. Okay. So she goes further on to say, are we really talking about $8.50?
no, the $8.50 is what our student legal services fees are. It's included in the tuition. So tuition has to be paid in order for students to be eligible for our services. It's part of the tuition.
You wanted to say something, Mr. Cassidy. I mean,
Yes, Your Honor, just as you know, she can't be here, she's in class. I know she would disagree with what Ms. Rose is saying. There's an engagement letter. It does not require tuition to be paid. The second part of it that Ms. Rosen does know is Paula has a payment plan with the registrar, in part because she's incurred for cancer treatment. Why Ms. Rosen hasn't told you that, I don't know. But she's been told by the person who runs the clinic that the actual fee at issue is $8.50. Paula has complied with the engagement letter 100%. She is currently enrolled and has a payment plan with the registrar that Ms. Rosen doesn't have access to, but she told me that's the case. So really, this is somewhat unfortunate pretext, as I think Paula says. More than anything, she wasn't given notice that this was going to be heard today, and she would like some time. If there's some resolution that can be SLS, great. Then if not, she'd like an opportunity to be here and explain her position.
Your Honor, if I may, the information that we received from the registrar's office. The only information that the registrar's office provided to us is that the tuition has not been paid. I don't have anything further from the registrar's office. Additionally,
okay. Would it be your understanding that if there's a payment plan that they've approved, that would suffice for the purposes of continued representation?
I don't believe that it would, as our fees have not been paid. I mean, the only information we get from the registrar's office is that the tuition has not been paid since the fall of 2024.
Okay, but I guess I'm a little bit confused, only because if a student was waiting on financial aid from get there, but they know that it's coming, I don't know that it would, and they're still attending classes, everybody's just waiting on the funds to get there. That may place them certainly in a circumstance where hold on one moment. Who was that? Oh, just tell her to walk in.
You want me to go tell
If she's got something.
her? No, she's going
Okay.
to.
Okay. Anyway. I don't answer knocks at the door. Okay, so if it would seem, I guess somebody, given her objection, somebody would have to clarify for me that if she has a valid payment plan with them, why that does not then provide for her to have access to the services.
Usually, Your
Right?
Honor,
Go ahead.
in a situation where where a student is waiting for financial aid, that's usually paid within a matter of weeks. This has been over a
Right.
year or almost a year at this point that the fees have not been paid. The tuition and fees have not been paid. And I also think, Your Honor, at this point, not to switch gears, but that at this point, I believe that there's been, in addition to the tuition issue, there's been a breakdown in the attorney-client relationship. I have been advised that it's Miss Cassidy's opinion that I am incompetent and unethical. I don't think that that's the basis for a continued attorney-client relationship.
Well, I was going to get to that next, and I'll just say this, and I understand people can have their views of attorneys and everything, but I'll just say it, that's not you.
Thank you,
And
Your Honor.
that as I read those statements that you were somehow unethical with her, or misrepresenting her, trying to provide a pretext, and then not only doing that to a client, I don't believe that at all. But further, that you would take that and provide that same information, some false representation or some misrepresentation to this or any other court that has never been the way that you practice. It is not you. And quite frankly, I don't believe it. So I'm just going to lay that out there.
Thank you.
I would then indicate, I think you're right, that I will grant the motion to withdraw, but not on the basis of the failure for the tuition to be paid. Because otherwise I'm going to get into a whole big whatever of, does a payment plan qualify? Does it not? Has the actual fee for the representation be paid? And I don't know that in the long run that's going to matter, because if I were to then deny the motion, Ms. Rosen and Ms. Cassidy I would then get another motion, quite frankly, asking that Ms. Rosen would be asking to withdraw because of a breakdown in the attorney-client relationship. And I would agree with that notion for the basis for withdrawal, particularly given the statements that have been made on this. And I'll just say one other thing. I've been involved in this case since its beginning, and I don't know the conversations that take place between attorneys and counsel, but I can tell you that, to the extent Ms. Cassidy can hear me on this, just understanding that Ms. Rosen has been a ferocious, and I don't mean that in a bad way, but a huge advocate for her and zealously representing her in every moment that she's appeared before me or when we've had our bench conferences. So I'm going to permit the withdrawal on the basis that the attorney-client relationship is broken down. That may be, quite frankly, to Ms. Cassidy's, certainly not to her benefit, because I think she had one of the best attorneys we have out there. So I don't know how much time she has indicated a certain schedule here, but I don't know how much time she's going to need to get an attorney to represent her in this Mr. Cassidy, you have any idea how long?
A week to 2 weeks. You know, we started working on it, however, this motion was given to us on a Tuesday, Thanksgiving, so.
All right. Before I do that, is anybody going to have an objection given the circumstances to an adjournment? I'll hear it, but I'm going to adjourn it anyway.
Your Honor, are you adjourning the motion, regarding
Well-
jurisdiction or adjourning?
I'm going to adjourn everything because I don't have somebody representing Miss Cassidy. I'm ready to hear argument certainly on that, but I don't know if Miss Cassidy's going to have a different position. So,
Okay,
and it may not matter. I get
yes,
it.
I
But
understand. Well, I guess the motion, just as a practical matter, the other motion before the court today is the motion for the court to obtain concurrent jurisdiction or to remove the circuit court. There was no objection filed by anybody. Is the court still inclined to adjourn that as well?
yes.
Okay,
I understand why I may not, but it seemed, given Miss Cassidy's objections, that she was much more preoccupied with the withdrawal counsel. So I don't know if that was addressed.
okay.
Put it that way.
Then, Your Honor, I would request we have a specific time frame. It sounds like they were open to 1 to 2 weeks to obtain new counsel. And then, moreover, the court had previously requested or ordered that the defendants answer any amended pleadings as of yesterday.
Yes.
That did not occur. So we would further request that a new deadline be ordered by the court and that it be honored for answering the complaint and filing any counterclaims.
And that was from the Cassidys. That's
Correct.
right. Mr. Lloyd.
I'm perfectly comfortable with adjournment. I do need more time to properly address the claims that are made. And I was going to be making the same request the same relief for different reasons.
Got it. Okay. So I love scheduling things in December. I have the 2nd, 9th, 16th, and then January 6th. Quite frankly, I think the practical is going to be January 6th because by the time counsel gets involved, that's going to give you enough time, Mr. Lloyd.
Yes.
By the time Miss Cassidy gets counsel, they've got to figure out what's going on and get an answer. So I'm going to set this for the 6th. Answers by both Mr. and Mrs. Cassidy need, as well as any counterclaims, would need to be filed our last day before the holiday being open. Well, I'll give you 3 weeks to get that done. So by the 23rd
Thank you.
of December. Will that work?
Yes, thank you.
Yes.
All right. Is there anything else from anybody else? Ms. Rosen, did you file a proposed order with the court? I don't.
No, I will
No,
submit one though.
All right, please do that. And why don't we do this in that order that I've allowed to withdraw? If you could include those future dates and when the answer's due so that once
Sure.
that's served by Miss Cassidy, she'll know. So if you could do that for.
Sure,
Yes, I
could you just
appreciate it.
remind me of the dates?
Yeah, the 3rd of December, the defendants, counter plaintiffs in this case are to answer the complaint and file their counterclaims by that day,
And then returning to court January 6th?
January 6th, 9
At what
a.m.
time? 9 a.m.?
9 a.m.
6th is a Tuesday.
It is.
Thank you.
And that's to hear the motions and for a study.
That's it.
conference?
Yes. Hear the motions, and I think I've got to hear the motion before I can decide what we're going to do. So,
Understood.
all
Thank you
right.
very much for your time, Your Honor.
Thank you. Thank you, folks.
Thank you.
Thank you.
Thank you, Your Honor.
Pardon? Thank you.
Court will call at this time State of Kansas versus Austin Van Stuber, case number 2025 CR 201. Mr. Stuber appears at the Butler County Detention Facility Zoom location. Brett Sweeney for the state of Kansas. Chris Pate is defense counsel. This matter comes before the court at this time for sentencing. Court's docket notes indicate that this defendant appeared before this court on October the 6th of 2025. At that time, the defendant pled no contest to count 1, possession of methamphetamine, a level 5 drug felony. A pre-sentence report was ordered, sentencing set for today. The court has received a completed pre-sentence investigation report compiled by Tony Bauer, pre-sentence investigator, who is present on this meeting with us. I trust each attorney has received a copy of this report, and I'll ask the state's attorney first. Is there any objection to the criminal history which is stated in this report?
No objection, Your Honor.
Any objection by the defense, Mr. Pate?
No, Your Honor. I've reviewed the criminal history score with Mr. Stuber, and we do not have an objection.
The court will adopt the criminal history score as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score E, and the court will proceed further accordingly. Mr. Sweeney, do you know of any legal reason why sentence should not be pronounced in the Stuber case this morning?
I do not, Your Honor.
Mr. Pate, are you aware of any such legal reason?
No, Your Honor.
Mr. Stuber, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing here today?
No, Your Honor.
Court will proceed further then. Counsel, I'm not aware that there's been a motion for a departure sentence or any other sentencing related motion to take up at this time. Does the state have any such motions to pursue?
No, Your Honor.
Does the defense, Mr. Pate?
No, Your Honor.
Are there any victims or members of a victim's family present who desires to address the court in relation to the Stuber sentencing? No such persons appear, so that at this time the court will ask for recommendations from counsel regarding an appropriate sentence for Mr. Stuber, beginning with Brett Sweeney on behalf of the state of Kansas.
Thank you, Your Honor. Your Honor, the state is requesting and recommending, rather, the standard mid-box 20 months in Department of Corrections. That would include the 20% good time percentage, as well as the 12 months post-release supervision duration. As far as jail time credit goes, he has been in, and I believe still in on this case with a hold. My calculations in contact with the jail put him at 115 days of jail time credit. So, quite a bit more than what the PSI has, at least the one in front of me. Did you
see the explanation in the pre-sentence report, Mr. Sweeney? Apparently, he's been ordered to KDOC in another case as of September 5.
And I knew he was ordered to KDOC as of September 5. That, I think, triggers an analysis under, some existing case law that's out there. And I still think that maybe he would be given credit for that 115 days. But I don't know. And I'll let Mr. Pate speak to that too. But in full candor, I think I have to just raise that. And I guess it would also maybe depend on how the court runs this case, whether it runs it consecutive or concurrent. I'll let Mr. Pate speak to that as well. But I do think that is an issue. He is in KDO. There is the KDOC commitment, and I says that that's for 22 months. He's presumptive probation in this case. So I don't know how the court wants to deal with that. Obviously, I think the court has to put him on probation first, and then maybe there has to be an analysis beyond that about how long maybe we want to wait before we do a revocation. But if he is placed on probation, I think that all the conditions that are within the PSI report are appropriate. He's got one of the more interesting criminal histories I think that I've ever seen, with so many drug convictions that looks like they were all adjudicated like on the same day in 2011. It's very interesting. But as far as costs and fines associated with the case go, Your Honor, the state's not requesting a fine. That was part of the plea agreement. We are requesting the court costs in the matter. KBI lab fees, lab reports were completed. If the court does place him on probation, we're asking for community corrections and supervision fees, attorneys and bids fees if they're appropriate. And then we would ask for this case to run consecutive. I would note there's a special rule. We would ask for this case to run consecutive. And I think it's to that KDOC case that he's been revoked on, which is the 24 CR 17.
Mr. Sweeney, because of the application of the special rule that this crime was committed while he was apparently on probation for another felony, this wouldn't necessarily be a presumptive probation case. The court could invoke the special rule and send him to prison on this case without any further finding. Would you agree?
I would agree with that. I would tell the court that, normally it's the state's recommendation in these situations, and I think it was consistent in this case as well, that the state wouldn't necessarily or recommend the discretionary special rule. So, and I think in full disclosure, I have to let the court know that was part of the plea agreement. Although I would certainly admit that his commitment on the other Butler County DOC case does complicate the matter with respect to whether or not he's going to be able to complete probation with a 22-month commitment date on the other Butler County 24 case.
Okay. We're talking about Butler case 24 CR 17, are we not?
That's correct, Your Honor.
All right. All right, Mr. Pate, again, interesting set of legal circumstances here. So what is your recommendation regarding an appropriate sentence?
Your Honor, our recommendation in this matter is that the court follow the presumption and place Mr. Stuber on probation. I believe it'd be for an initial term of 12 months. He's not eligible for Senate Bill 123 because of prior criminal history. I think this would have to be consecutive under the special rule. And obviously, as the courts noted, there is the option to impose prison. But like the state, we are not requesting that. I did not represent Mr. Stuber on the other case, but it's my understanding, and this is just based on discussions with Mr. Stuber, that with all the credit for time served on that case, potential good time and things of those nature, that he should be released from KDOC on that case in less than 12 months. So I think we're in a situation here where he could foreseeably complete a probation program. He's not going to be incarcerated for multiple years, or it'd just be impossible to do so. As to the jail credit, the PSI notes the 26 days. Depending on what was ordered in the other case, unfortunately, I think that's correct. We're all aware of the Irvin case, which kind of changed the rules on credit for time served, but then 216615 was modified after Irvin, and then it's section A2 that deals with that states that he shall not be considered incarcerated for any time that's awarded as credit in another case. So while I would love for him to get as much jail credit as possible, I think I've got to make the court aware of what my view of the law is, and I don't think that would be awarded here, assuming he's getting credit in the other case, which I think he probably is, and that's probably what gets him down to having less than 12 months to do. Mr. Stuber is You can tell from the criminal history, he's got a drug issue. He recognizes that. He's been incarcerated now in some way, shape, or form since August 11th. He's going to be in for quite a while longer. So he's going to have a period of forced sobriety. I think he is serious about getting sober. I know those have been the discussions that I've had with him, that is definitely something he's going to do. I believe he's been looking into sober living facilities upon his release. So I don't think there's any prior person felonies here, as noted by the criminal history of E. As we've said, this is a presumptive probation case, but for the discretionary special rule, we would ask the court, give him that opportunity at probation, given that he'll be out in less than a year. Obviously, an extension of probation may be necessary depending on what conditions are imposed, and we would certainly understand it if that occurred down the road.
Well, I think a question to the community corrections officer on this meeting might be appropriate. Ms. Ashenfelter?
Yes, Your Honor.
So if this court were to follow Mr. Pate's suggestion and place Mr. Stuber on probation in this case, even though he's going off to prison, how is a case like that handled in your office?
Your Honor, if that occurs, he would remain on probation until he gets out of DOC. The only issue that comes with that is if he's going to expire. By that time, we would have to voluntarily have him sign an extension or file a warrant.
Mr. Pate, I don't know how you computed Mr. Stuber's DOC sentence. I trust you credited all good time credit and tried to present to the court the earliest possible release date?
That was primarily based on what Mr. Stuber had communicated to me. So I definitely wouldn't hold me to a specific date based on that. I'm going to try to look him up here and see if I can provide any more information.
There's no official out date in Casper, because I had already checked that before, but I'm trying to pull up the actual journal entry.
Judge, the notes in his other case on 9/5 say his sentence was modified from 30 months to 22 months. And he was to get any jail time credit with 15% good time credit, 24 months post-release, but that's all it states.
So essentially, those are notes from a probation revocation proceeding, correct?
Correct. Yes, with Judge Crum.
That was done on 9/5.
So that would, if he got his good time, and since 9/5, I calculate that having him down to 15. So I suppose the next question is how much jail credit was awarded at sentencing.
And I'm pulling that up right now. Your Honor, I think I'm going to have to. This can't. I'm looking at the journal entry that's filed on September 11th of this year for the probation violation modification, and it's saying that he was only awarded no days of jail time credit, or one day or no days. So
The one I'm looking at shows 1 day jail credit and sentence to begin on 9/5 of 25.
mm-hmm.
So he was credited for none of the time that he's been serving recently?
That's at least what the journal entry indicates.
Well, that's
why I'm saying, Your Honor, it doesn't. I probably need a little bit more time to look into how that was calculated. And obviously, when you get multiple cases, it gets a little tricky as to where that gets awarded.
Mhm. Well, it obviously wasn't credited there. At least the record in the case doesn't indicate that it was credited there. All right.
Your Honor,
Yes.
I believe the current incarceration, all that time went to this case up until that 9/5 date when he was ordered to DOC in the older case. So I gave him credit in this case for all the time up until September 5th.
All right. He was placed on a no bond hold in this case in August due to a failure to appear. And apparently was picked up a few days later and has been held in this case ever since. But I'm having difficulty reconciling the facts before the court with what that journal entry in the other case states. That they've only credited him with one total jail time credit day against that DOC sentence in the 24 CR 17 case. I don't see how that could be.
Your Honor, if I may, Joe Fabier said that I was credited 31 days altogether from the time that I turned, because I called and turned myself in and had the registration officers pick me up. And then I believe I didn't bring my paperwork, I'm sorry. And it said that it was credited 31 days.
Right. I don't know where that's documented, Mr. Stuber. I don't doubt what you say. I just don't know
I
where it's
understand.
documented. All right. But I understand your position, Mr. Pate. To some extent, anyway. At this time, the court will address Mr. Stuber personally, and I'll ask him if he has any statements that he wishes to make in mitigation of punishment or anything further that he would like to present to the court. Mr. Stuber?
Your Honor, I thank all you guys for coming in today, and I know that what I've done, I'm owning it, just like I did on my first case. I finally came to realization that I've tried to wiggle my way out of most things in my life, and I've never really owned my stuff. So I know what I've done. I've chose to put drugs and fast living in front of my daughter. She's the main one that I'm concerned about that's losing time for me. Since I've been in here, I've done a lot of thinking. It took me hitting the ground floor really hard to wake me up. I understand that, there is a possible sentencing of 8 to 22 months. Whatever the court deems correct, I think will be just. So I just put it in your hands and ask for mercy. Thank you, Your Honor.
Thank you, Mr. Stuber. I appreciate your statement. Court will proceed to sentencing in the Stuber case at this time. Court hereby establishes count 1 as the base sentence in the case for the offense of possession of methamphetamine, a severity level 5 drug, non-person felony, in which the defendant has a criminal history score of E, thus placing him in grid box 5, drug E. The court hereby sentences the defendant to a term of 18 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. The court has considered but declines to impose a fine in this particular case. The court does note that there is a special rule that the court will apply in this case. This crime was committed while this defendant was on probation. Apparently in case number 2024 CR 17, the court will run the time in this case consecutively to the time imposed in 2024 CR 17 out of Butler County. Further, the special rule essentially would negate any presumption of probation in this case should the court elect to apply it, and the court will do that here. Mr. Stuber, the court would really like to see you out in the community over the next several months, facing a rehabilitative program and dealing with your drug issues. I've never seen a criminal history like yours. I share Mr. Sweeney's astonishment as to what the pre-sentence report revealed with all of the drug-related charges that you've had in the past. I've also noted that you've had some other criminal history as well, which was not drug-related. Because you're going to go off to DOC in 24 CR 17, you're not going to be in a position to be able to pursue any type of community-based drug treatment or rehabilitation program for what looks like at least a year, if not more. It does not appear that you're amenable to a probation in this case, and the court will simply apply the special rule and order a prison sentence in this case. This court has imposed the mitigated, in other words, the minimum sentence, if you will, Mr. Stuber in this case. And I hope you earn every good time credit day that you possibly can to reduce that sentence. Furthermore, this court is against the concept of dead time, and I'm going to make sure that Mr. Stuber gets day-for-day jail time credit in one of these Butler County felony cases, and the court essentially will adopt Mr. Sweeney's computation of jail time credit. I don't think that there's necessarily anything patently erroneous about the officer's computation, but I think some time that he presumed would be credited elsewhere does not appear that it has been. And the court's going to grant the defendant 115 days jail time credit in this case.
Thank you.
There's no restitution order to be made in this case, unless there's a KBI lab fee that I need to consider. Mr. Sweeney, do I?
There is a KBI lab, Your Honor.
$400 KBI. Restitution is ordered. The defendant is ordered to pay a felony docket fee in this case. Any bids assessments are waived here due to the court's incarceration order. If these amounts are not paid in full within 30 days of today's date, the court will order that these would then become collectible by sending to a collection agency. And all amounts will become due, payable, and collectible after that 30-day period passes. Some point in the future, Mr. Stuber, you may have the right to seek expungement of this offense. Certain statutory limitations do apply. If you have any questions about your right to seek expungement someday, you can address those to a lawyer and I'm sure get your questions answered. Under certain limited circumstances, a criminal defendant may have a right to appeal their conviction to an appellate court having jurisdiction. And if a defendant is unable to pay the cost of an appeal, the defendant may request the court to appoint a lawyer to represent them on appeal and that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 22-3608C, Mr. Stuber, you, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the district court of Butler County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. I will remind you, Mr. Stuber, that there are prohibitions against a convicted felon possessing a firearm, and that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. I will remand Mr. Stuber's custody back to the sheriff of Butler County until his custody can be transferred to the Department of Corrections to serve the remaining balance of the 18-month prison sentence, which the court has imposed here today. Mr. Sweeney, is there any other sentencing related matter that the court needs to address or readdress?
No, Your Honor.
Mr. Pate, are you aware of any sentencing matters that the court still needs to address here?
Not at this time, Your Honor.
Mr. Stuber, I think you've come to a realization where your attitude has to change, and I think it has. If you can keep the mindset that you have today throughout your incarceration period, seek whatever rehabilitative help that you can within the Department of Corrections, I think you actually got a chance to make it when you get out. And I hope you achieve that as soon as you can and that you are successful when that time comes.
Thank you, Your Honor. There's only one thing is I was told that to ask for the possibility of work release. I do have a daughter out there that I would like to help support or a PI job because the mother of my child is kind of struggling right now. So if there is anything that the court could help with that, just to make sure that I could get into one of those programs, I would appreciate that very much.
All right. Well, as far as jail is concerned, the court would have the power to order or authorize work release privileges, but you're now in DOC custody.
Okay,
I think that the rules will likely change for a DOC inmate who just happens to be still held in a Butler County jail facility. And I would expect, Mr. Stuber, that your transfer to the Department of Corrections will happen very soon
okay,
after this. So I'm not adverse to that necessarily, but I just don't think that the sheriff's office is going to release a DOC inmate
yeah.
onto a work release program, even though you're incarcerated in the jail. So
Yeah, no, I was talking about KDOC. It might have been just jail talk, but they were like, your judge has to approve you for KDOC work release or whatever, or have that as an option. So,
I have no opposition to you being
okay,
in any work release program that the Secretary of Corrections authorizes.
okay, thank you, Your Honor.
No, I actually think you'd be a good candidate for that if such a thing exists.
Thank you, sir.
All right. If there's nothing further, then thank you all for your patience this morning in getting started. The Austin Van Stuber matter will currently be in recess, and this meeting may be ended.
All right, this is case number 2500009 GC Benet Brown versus Meyer.
No, you.
What happened?
Sorry.
Well, you got a little confusion there. Okay. Let's see, it says there's a document not received. So let's see what's in here. Okay. Not reviewed. Okay, but we have a name for the record.
Judge Johnson, Benet Brown for the record. Morning, Judge Chelsea Hall on behalf of the defendant, Bryce.
All right, and let's see. We're here for a motion for summary disposition. This was filed by Meyer. Okey-dokey. Did you, I guess, got something here? Because I guess it was filed yesterday. Did you receive that?
Yes, Judge.
I didn't see it, but I'm looking at it now. It's a response to your motion. That's what it says.
I'll count a response. If I may, Your Honor, it's a response to our reply, which would be improper under the court rules.
Oh, yeah, it does say that response to the defendant's reply. Yeah, you don't get a chance to file a response to a reply.
Well, I'll just use that as my opening statement.
Okay, well, go ahead. It's her motion, so she goes first.
As Your Honor, the right of the process letter was reacted. Ms. Brown stated that there were scrapers in Meyer Southfield, Meyer store that fell on her, supposedly claiming that they were improperly stocked or stacked. As Your Honor, I'm sure is also aware under well-established Michigan law, it's the plaintiff's burden to prove that the defendant, Meyer in this case, had prior notice of any alleged defect before the actual incident occurred. Plaintiff has failed to produce any evidence that Meyer either knew or had reason to know or should have known that the ice scrapers were stacked incorrectly before the incident actually occurred. Plaintiff testified at her deposition that she didn't see anyone from Meyer actually stack the ice scrapers that day. She also
Well, you know, and I guess I should ask the plaintiff that, but when we reference the term, quote, improperly stacked, exactly what is the standard of care for stacking? I don't know how they were stacked. And okay. All right, we'll get to you then. Go ahead.
Yeah, and to address Your Honor's question, I think we attached it to our brief as well. She did submit a picture along with her.
Let's see, I might have printed your brief.
I know I have the photo as well, but
You have it in black and white.
no, I have the color.
Oh, you have it easily handy? Okay, yeah, I'll take a look at that.
There's two. one for the proper stacking and the one after it fell on me.
Thank you.
I took both. Just not see. Thanks. And I do have the original picture with the timestamp.
This is after the,
Yeah.
oh,
Right.
is there one, well, you wouldn't have had one before or you did?
After the manager took them and stacked them correctly.
Okay, well, let me see that one.
I don't know if that's, is this one you're referring to?
Thank you.
That's when she submitted, I believe, in
Yeah.
her.
The next changed, to the side after the accident and after he stood there momentarily looking, he hurriedly picked them up. But I had already taken a picture. I was standing right there and picked up one. They all just started cascading and hitting.
Okay, I get it, but I'm just trying to look and see.
Now there's one, Your Honor, if you can see, that's standing with the blade down, with the handle up. That's the one I actually picked up when they all started to fall. So when I put it down, I put it down, blade down. Because, you know,
I don't see how they were
they were stepped on it, they were.
This picture doesn't show me how they were stacked before.
Picture that I drew myself. I can show you from, well,
Because you allege that there's a proper way to stack these things, and I'm unaware of a standard of care for how it should be quote
with the
stacked.
blade down. With the blade down so as not to injure anybody. The blades down.
Okay, and your position is that they were stacked improperly
They were all standing there propped up when I came.
with the blades up.
Yeah. But it didn't dawn on me anything was wrong because they were all there standing. As soon as I picked up one, they all just start falling. Hitting, striking me multiple times.
Okay, well, I don't know how they were stacked up or down.
Let me show you.
Maybe they weren't secured properly. I'm not sure what you're saying, but
I drew up, sort of a picture of these people who that idea of how they were stacked. One second, you're on.
all right.
Thank you.
Then we'll get right back to you as soon as she finds whatever this drawing is. I guess it's a drawing. I just want to make sure I've got the complaint, the argument right on the actual complaint. That what we're dealing with is stacked. I remember it from before, but I wasn't exactly sure because I never saw the photo.
Right here, right there. Is it okay to approach?
Yes, that's right.
Miss Kelsey submitted this in her supplemental responses. That's how they should have been. Okay, I'm
Okay.
still looking for I don't have this picture, they.
Right, this is the one where they're stacked down.
Yeah, definitely. Let me.
And you also have this one that she showed, which is yours, that shows them with the blades down. I just don't have one that shows what they look like before.
I just saw it last night. I went through all of them. Cause I drew it myself, you know. This is motion for discovery. Here, I don't know. I have it.
I also have a copy of it.
Yeah, that I think I've got here. Yeah.
Bear with me.
Yeah.
No, it's here. It's,
Here's the complaint.
There was the original and then an amended one.
Oh, okay, this is probably the original. Let's see, amended complaint. Amended complaint. Here we go.
That'll be in here, it's the last one. Here it is, Your Honor. Can I approach the bench?
Yes.
Yeah, I drew this. This is how,
Can you show it to her for?
this is how it was propped up.
Did you submit that to?
Yes, I did. Okay. And then my prep period was submission.
Okay, thank you.
You're welcome. They were stacked like this. They were
Oh,
standing
okay.
up
So
there
they're
propped up.
propped up,
Yeah,
secured by the thing.
just propped up. Somebody had, I guess, propped them up, but yeah, when I picked up one out.
What is this around?
Whatever they have there holding, usually the handles. That's
That's
just my
right here.
interpretation. I mean, I don't know.
So that was something to.
It was like two pieces.
To stand.
Yeah, one on one side from the other looked like tools. They had propped it around, and then one on the other side. So they were,
Not these.
yeah, it was that. They propped up in between there,
Okay.
some kind of way. You know, maybe with the one next to it. I don't know for sure.
Mhm.
But they were like this.
Yeah, I see.
Yeah.
All right, go ahead, counsel. So you can kind of start over because I probably interrupted your train of thought with that.
So, maybe this goes towards the point, right? But the fact is plaintiff has the burden to prove that we had actual constructive notice before the incident actually occurred. So it's fine that she took the photo afterwards and she has a drawing, but she hasn't offered any evidence that Meyer actually had actual or constructive notice. It's the way that these ice scrapers were supposedly stacked. I mean, she was questioned about this after deposition, and she even admitted that she didn't notice anything odd about the way that they were stacked. And I specifically asked her at her deposition, hey, let's not talk about what you saw in your mind's eye. Did you actually see that they were stacked improperly? And she said, no. That's on page 80 of her deposition transcript. I'll remind this court of the case of Valdez versus Menards, in which something extremely similar happened in a Menards. The plaintiff there had tile fall on her, and she wasn't, and the court found that just because plaintiff claimed that she believed that a set of tiles were stacked improperly because they fell on her, that doesn't mean that Menards had actual or constructive notice. The Court of Appeals found that, and I think that case is analogous to the one here today. And plaintiff simply have offered, no evidence that Meyer had any actual or constructive notice. She testified that she didn't know how long they were actually stacked like that. The Court of Appeals stated in the Menard case that merchandise that's set out on display in a retail store is subject to being handled by different customers in the store. There was nobody in that aisle. She testified to that. She testified that she didn't see anyone actually stack those ice scrapers improperly. And she just has not offered enough evidence to meet her burden. And there can't be a dispute of material fact based on the evidence that has been shown to this court. So we ask that this court grant Meyer's motion for summary disposition and dismiss plaintiff's claims with prejudice.
What date you filed this motion with the exhibits?
August 25th, 2025.
Thank you. That helps. Let's see. Motion for summary. This is a proof of service. Let me see if this is the motion. No, that's a motion to compel sign authorization. Here's a motion for summary. I see the proof of service on the motion for summary. Motion in limine, motion for protective order. I'm just looking for an exhibit, which is you have attached the case as an exhibit. I was looking for that, but I don't see.
I should the very last exhibit, and I have a copy of it.
What date is that gonna be?
I don't know. I'm looking pursuant to filing dates here, and I see August the 26th. It says there was a motion filed, but it was a motion to compel some authorizations.
Yeah, I think that's the day we came in here.
Then-
and, she didn't know, she said, that I had stipulated a motion to compel discovery.
Yeah, no, ma'am, I'm just looking for something different.
Oh, there.
I'm saying that's the only thing I see. That says here that there's an electronic proof of service on the this defendant's motion for summary disposition. August the 25th. Where's the motion? I see the proof of service saying you served it on her. It's really weird. Says this one says motion of compelling discovery responses. I know it's in here because I have a copy of it. So it's just, and I don't think this copy has the exhibit attached. Let's see, maybe it does. Let's see.
They're looking for the basic survey. I do have a copy. If you
Valdez. Yeah, there's two that you cited that were Menard's cases, but they're like not.
it would be persuasive authority then.
Yeah, I'm gonna need to see that because it's not attached to what I have, even though it does say that it's exhibit number 5. And then you have exhibit number 6, another one. Mm-hmm.
Eastern District Court case and then Valdez.
Is the Court of Appeals. Mm-hmm. I might be able to pull that up if you don't have it handy.
I do have them right here. If you
Oh, yeah,
Can I approach?
sure.
And then the relevant portions are highlighted as well.
Okay, all right. So, well, you heard the defendant's recitation of the law and then their recitation of a case that they believe is on point here that governs this situation. Did you have any response as to whether the law is wrong or whether the case is wrong
Yeah,
or should be construed differently?
yeah, it should be, I have an opinion that it should be construed differently.
Okay, well, what do you have?
Okay.
Not your personal opinion, a case.
No, a case.
Ma'am, we have to deal on case law. And so she has provided the law on this type of liability, and she has provided a case that deals with a similar situation under this train of legal precedent. And we're dealing with liability here on these premises. So she has made an argument, and I'm just asking you if you're responding to her. It's in the brief, so it's not like you didn't see it.
Well, I'm not gonna respond to the argument with case law, okay?
Well, ma'am, that's what we do here.
Okay, well,
I need to know because I'm going to rule on this case.
I have something I'm sure.
Okay.
I read it and all of them that I can find that can assist me. So you don't want anything but the case law.
Well,
Because I have other.
listen, whatever you think you need to present it.
Okay.
But I'm telling you, I'm going to have to rule based upon the state of what the law is.
Right.
And basically, I mean, you haven't told me if you think that their recitation of the law is proper or improper. I'm just checking to see where you are on this.
Well, let me just have a preamble before I address the law. Okay, it doesn't matter how the items were stacked. Only that they were stacked in an unsafe way that caused my injury.
Okay, did you hear the law that she recited? Let me help you. So basically, the argument under the law is that you have to show actual or constructive notice of the dangerous condition in order to even establish the case. Okay? So actual notice means, ma'am, I didn't write this train of law. All I do is you can't disagree with it. It is what it is. It's the law.
Is that a law in Michigan?
Yes, ma'am. It's a law of premises liability is a concept of law.
Yeah, but if I knew there was a liability, I wouldn't have even approached.
No, I said you have to show that Meyer knew, not you knew.
Well, they should have known, because by the incident report, the manager said that no one walked the premises looking for any,
Well, that shows that they didn't know. You got to show that they knew or, quote, should have known.
they should have.
Constructive notice. Let me define it for you. So we're talking about the actual notice or constructive notice. Constructive, it means the set of circumstances were such that you should have known that this was a problem. So constructive notice is present when the hazard was of a character, such a character, or had existed for a sufficient time period that a reasonable premises possessor, that would be Meyer, would have discovered it. So you're going to have to show how long that problem was there. Not that it was there, but how long it was there, that it was there and how long it was there. And that it was such a hazard that they should have known based upon all of that.
Okay, all right, well.
And so you got to have evidence of that. Like perhaps you did some discovery and you asked some questions of Meyer as to who stacked the things. When did they stack them? Wait a minute, ma'am. You're too busy trying to argue with me. You won't let me guide you through what I'm telling you I need to see. Maybe you have done some discovery and asked those types of questions, or you've asked questions like, were you aware that this condition existed prior to the date that it happened to me? Some answers to some questions, something that shows that they would have known, because if no one reported it to them, or there was no record that somebody reported it, and it doesn't have to be that, but there's got to be some basis where you can assess liability. It's not just the fact that you were allegedly damaged by it. They have to have notice of it and not fix it. So let's just take your scenario, for instance. So this happened to you. Now, Susan Smith comes in a week after this happened to you, and she's looking at these same, whatever they are, shovels, and they're still there after you have reported it as an injury. Then we know in that scenario, they should have known because you reported it. Someone responded to the report and the things are still there. That is some evidence that they should have known about this. We need something from you. I'm not saying we need somebody to have had an injury before you, but we need something to show that management or someone in authority was aware of the situation and that the situation was, bad enough that you or someone could have been injured and that they knew of it and that it had been there for a period of time and they didn't do anything. That's what we need to establish the constructive nature.
The attorney, he sent the mail letter with all of that.
Okay, what is it that you specifically has? Because her argument today is that you have not shown how long the things were there, or that Meyer somehow should have been aware of it before this incident happened to you. Her argument is that you say these things were shelved incorrectly, but there's no evidence that Meyer even knew that somebody had shelved him wrong, that their employee had done that. If that is wrong, we have to have something that shows that, because otherwise, as she argued, there's really no factual issue here.
My previous attorney asked for all of that from them. Who was working?
Okay, well, what did they get?
They did not respond.
Well,
they didn't respond.
Well, then why didn't your previous attorney do a motion to compel the response?
After holding on.
Well, maybe he did that for a specific reason. I don't know. But then it's incumbent upon you to pick up, and I know you're not a lawyer, but when you're representing yourself, you have to be a lawyer. I have to hold you to the same standard as if you were a lawyer. I can't give you any benefits of the doubt because you're not one. And I can honestly say that I've seen people do great jobs when they're not lawyers, but you have to.
the things that are on my plate.
I understand that. Sure I do. But I'm saying I can't take that into consideration. So once your lawyer stepped out of it and you saw that he allegedly never received any responses to the discovery, because I don't know if he did or not, but let's just say that's true, then you would have to step in and file a motion to compel the responses. I think they filed something to compel something. You could have done the same thing.
The mediation
You asked who?
to provide
Okay, but that's not the way you ask. I mean, you can ask that way, but that's not a formal request under the court rules. That is you trying to have a good relationship with counsel, and counsel do that. They talk to each other and they respond without having a formal request. But I can't do anything about it if it's just an informal conversation. They agree to give you something and they don't. That's between you two. I can only respond if there's been a formal request pursuant to the court rules for some type of document or response to some interrogatory that was never responded to.
Wow.
Then I can take action.
Gave it directly to them. I could have put it in my request for interrogatory and documents, but I had no idea.
Yeah, but what we're talking about is for them to have given you some answers to show that how long this condition had been there.
Yeah.
Or who would have known? Who would have set it up? Would it have been the stock boy? Would it have been whomever?
Exactly.
If they have any idea when the product came in. So therefore they could say, well, we have a record that we at least received it on X date, we might have put it out a day or two later. We have nothing to show even when they put it out.
I did submit that particular item I'm talking about.
Okay, well, what is it you submitted to me?
Previous attorney, the demand letter had all of those things. You just made.
But you never got any information though?
Put it in the file and that was it. I never realized I could have and should have put it in the interrogatory request or the document request, which would probably been a futile attempt because everything that I've submitted to them through the interrogatory, the documents, they just shot them down anyway, saying that they're irrelevant. They're overburdened. So
well, if they say those things, you can still bring the issue up before the court. And I then decide what's irrelevant, what's burdensome, or something like that. But if nobody brings it to the court's attention, then there's nothing for me to do to make that determination. But they do their job because that's what they do. They're supposed to say they answer what they can, what they believe is proper to answer. They can object to things that they think are improper for various different bases. And if they object to something, then you have the right to say, okay, you're objecting to that. Let me bring that before the court and see why I can't get an answer to that.
exactly what I did with the stipulated motion to compel them to produce documents and interrogatory because the original packet they mashed together, it was illegible. Okay, so once again, after that, I decided to, since everything was irrelevant and overburdensome per the defense, I started to clarify and try to hone in on specific questions that were more inclusive and not so vague as they were saying. And so that particular day we were in here and you granted some of my motion for the stipulated discovery for them to present it.
But did you get those?
Yeah, they shot us down. She shot them down. She said,
Well, we're in a well, I can't do much about any of that now because that's really not before me. I'm just kind of outlining how it could have gone procedurally. Because right now we're at a situation where we got a motion and we call it a dispositive motion. That means it could dispose of the case in its entirety. So when we have a dispositive motion, argument is made, documents, are attached as exhibits and things like that, then you have to respond with other law documents and exhibits that create a question of fact, which should go to trial. Because right now they're saying you have not met your burden of proof under the law, so you don't even get to trial. What do you have? Because I'm not sure. What do you?
The manager, Mr. Banish, is the only document they ever presented me with was his incident report and a witness statement from an employee there, Marjorie Brown. So,
Okay, well, ma'am, what it,
well, let me get it and I'll show you, because I guess they didn't think it had anything in it, so they just disregarded it. But it's very, it's full of a lot of information. Okay, look, can I pull it out? Thank you. Okay, here it is.
I mean, one of the reasons that they make the law ensures that we have this information about temporally what time it happened, who might have done it, who might have known it, because this is a store. And who knows, you know, people go up and down the aisles and misplace things,
Center aisle.
pick things. So it's a store. It don't have to be hidden for people to rearrange things that are there. So, you know, you needed to say, well, you know, my employee did it. This is when, you know, those things were done. At least that gives you some time frame.
In here, in the reply.
Okay, well, I need answers.
In the reply that
You need to show me what you have that creates the question of fact that Meyer knew that these things were allegedly shelved like this, that they were wrong. Because it's a lot more than just the fact that you were injured or allegedly injured.
Yeah.
Yes, ma'am, whatever you got.
Okay, this is the only thing that they have afforded me, other than an incident report from an employee. She didn't see it, but she heard it. She was aisles away.
Okay, but that's the incident. We're talking about things that would suggest knowledge of Meyer before the incident. That's what we're looking for.
What about after the incident?
That doesn't
Within
matter.
minutes of it.
Ma'am, we're looking for, in order to hold them liable, they have to have known about a dangerous situation and failed to rectify it. Not after the incident, before the incident. That's what the standard of proof is here.
That doesn't even make sense. Anything can fall on anybody. But I'm just saying, anything can fall on anybody.
Just because something failed doesn't mean there's liability.
I picked up one and they all fell on me.
Ma'am,
Okay, let me just say one thing.
let me have you stand back.
Sure, I will. Can I say one thing?
Back over there, you can. Sure. What I'm trying to help you distinguish the two concepts. If you were injured, if they fell on you, that is one concept of your ability to recover. You have to have some damage and an injury there. That's not all of it, though. You have to show responsibility in a premises liability case that they knew of this problem that caused your injury. Injury alone is not enough. That's the best way I can sort of describe it to you.
Let me give me 1 second. I put this back in order. I mean, not out of order completely. I'm gonna put this one.
Well, don't have a lot of time here to rule on this. Yeah, I understand. But what I'm trying to say is, Ms. Brown, I'm not by any stretch of your imagination trying to trivialize the fact that these things fell on you supposedly and that you were injured supposedly. I'm not. But in order to hold liability, you have to know same thing like at your house.
Mr. Smith created a tort, okay? He created a tort. Well, let me find that so I can elaborate on that.
Who is Mr. Banish?
He's the manager.
And
There.
he created the tort.
Yeah.
What would he have done since you called him in after the fact, didn't you, to tell him about this?
But he was there for 2 hours. The store was already open.
But what tort did he create that relates to this? And what theory in your complaint even suggests that? You can't just make up theories like this. It has to be stated in your amended complaint. And the only thing I saw in your amended complaint was the allegation that these things fell on you and that there was liability by Meyer.
Okay.
Nothing about Mr. Banish doing anything after that.
Maybe you didn't see.
I'm looking at it, ma'am. I could pull it right back up.
Submitted 3 different amendments to the plan.
I have 1 amended complaint. I do not know of a third,
It should be another one there.
but I can find you amended the complaint 3 times.
So how about you, what you said you cannot accept?
I have a complaint, and here's the amended complaint filed on March the 20th of 2025. And the amended complaint simply says what you say happened about the scraper, how they began to fall. You told somebody and an employee what happened. They got the manager, you asked and said, I've been injured. The manager came, said she didn't know what happened.
No, he said he did know what happened.
The manager, our plaintiff, explained that she did not know what happened. So that's you.
Oh, right.
The scrapers fell. The manager began to immediately pick up the scrapers. All of this relates to that situation. There's nothing in here about Mr. Bannon and.
It's right here, what I submitted yesterday.
Ma'am, you don't have a claim, and I'm not listening to that. That's all I'm going to tell you. We don't fish around to find new theories at the last minute. You have to have stated, they have to have proper notice. Okay, ma'am, listen to me. Meyer may be a big company, but they also have rights too. And they have a right to know what your claim is. And that's why you stated in an amended complaint. What is the claim? There's nothing in here that talks about Mr. Bannon creating any tort. The only thing that's in there is about what happened with those ice scrapers.
They supplied me with the scrapers in the correct position. Why didn't they supply me pictures with the scrapers up in the air if that wasn't the incorrect position for them to be in? If that was a common position for those scrapers to be in at my store, why didn't the picture she supplied me for the supplemental additions to the discovery show that?
Ma'am, I don't know anything about why the pictures to the discovery wouldn't show that. I'm looking for some evidence from you that Meyer, through any of its agents, knew or should have known that this thing was stacked here and how long it had been stacked there.
I don't see how that,
Okay, well, I'm done with your side. Did you want to respond anymore? I can't, there's nothing more I can do. And if you don't have any more evidence to suggest anything, I have to rule.
I don't have any more evidence. Can I say something?
What is it would you would like to say?
I want to say Meyer will go the route of Walmart and Target. That's all I want to say. Thank you.
I'm not sure what you mean.
Well, and when anybody thinks about it, they'll figure it out.
Did you want to say anything else? Okay.
I have no,
All right, the court's ready to rule on this. This is a motion for summary disposition filed by Defendant Meyer. The facts are that the plaintiff alleged that she was injured in the Meyer store. We're talking about the Meyer store, Southfield, when sidewalk ice scrapers fell off of a display onto her. The plaintiff claims that when she picked up an ice scraper, the rest just started falling onto her. And she claimed that the scrapers were improperly shelved. That is, that they were upside down with the heavy metal part facing up. And then the handle was down. And that this caused some type of an imbalance that caused her some significant injuries, including her rotator cuff, tendon tear in the shoulder, in each shoulder, and some contusions. The aisle was empty when the incident occurred, and there's no video of the incident. The only tools that were allegedly stacked incorrectly were these ice scrapers that fell onto the plaintiff. Seemingly all the other tools were stacked with the handles up and the heaviest part down, as could be seen in the photographs that were submitted. No one knows when those ice scrapers were stacked, who put them there, and no one knows how long they had been stacked this way. Defendant denies liability and claims that Meyer had no notice that these items were allegedly improperly shelved. So to prevail on a premises liability claim, an invitee must show that the premises owner breached its duty to that invitee and that the breach constituted the cause or proximate cause of damages suffered by the invitee. And that's Lowry versus LMPS and LMPJ, 500 Mich. 1, a 2016 case. That's the Michigan Supreme Court. So basically, if you're invited onto the premises as a patron, you are owed a duty, and that breach of that duty has to be the proximate cause of injury. Breach occurs if the premises owner knows or should have known of a dangerous condition and then fails to protect the invitees by either repairing the problem or warning about the problem or some other appropriate mitigation of the danger under the given circumstances. And that is also the same case, Lowry versus LMPS and LMPJ. So actual or constructive notice of the relevant dangerous condition is an essential element in establishing a premises liability claim. Same case, pages 8 and 9. The plaintiff never claimed that the defendant had actual notice of this condition. And that's true. Rather, in this case, the plaintiff claims that the defendant had constructive notice. Now, constructive notice is present when the hazard was of such a character or had existed for a sufficient time that a reasonable premises possessor would have discovered it. So in this case, the plaintiff merely asserts that the scrapers were shelved incorrectly with the handle down and the scraper part up. There's no information or suggestion as to, as I said before, how long they were shelved like this, or that the defendant should have been aware of it. In fact, there's no real notice or information as to who even put them like that. I guess we're assuming that someone from Meyer did it, but this is a store and it could have happened in any number of instances other than a store employee doing it. And then if it did, we still would have to have some suggestion that Meyer knew that somebody else put them like that. Every other item in that particular area was shelved properly with handles up and the tool part down. Now, if the plaintiff is trying to suggest that the liability attaches simply by the mere fact that Meyer had those items shelved that way and created an unsafe environment, well, we'd have to have some proof that an employee placed the items upside down. And we don't have that since everything else was shelved correctly. And we can't make the assumption that somebody put them upside down from Meyer. As I said earlier, the public had access to items and people do strange things and reshelve things. So it could have been the public. There's no indication either as to how long they were there. Plaintiff seems to be looking for strict liability. That is, the mere fact that the scrapers were shelved improperly and fell on her means that Meyer should be liable. That's strict liability. That is not the standard in a premises liability case. Plaintiff must show that Meyer knew or should have known about the hazards. The defense did cite a case that was fairly instructive, and that was an unpublished case of the Michigan Court of Appeals, Valdez versus Menards, is number 344073 from November 26th of 2019. And in that case, back in 2017, a plaintiff went to Menards with her husband, mother, and stepfather to look at stickum linoleum, unquote, quote unquote, for use in her home. She grabbed one of the loose individual sample tiles that were, quote, at eye level, unquote, and another box of tiles weighing approximately 40 pounds fell onto her foot. She sustained serious injuries to the foot. Plaintiff believed that the box fell from the second or third shelf, and she did not know what caused the box to fall, and she stated that she did not do anything to cause the box to fall. Further, she testified that she believed that the tiles were shelved improperly because the shelves did not have a lip to keep the boxes from falling off. All right, well, from there, employees were involved and there was a lawsuit filed and, depositions were taken. There was some testimony about how a specific employee faced the aisle with products, making them flush with the edge of the shelving, and believed that everything looked perfect. There was also some testimony from a manager that when he arrived for work, that employee told him that he primarily worked on facing the aisle where the accident later occurred. Everything looked immaculate. And when he came back from lunch, there was caution tape at both ends of the aisle, and he was told about the incident. And he testified while he was working, he would walk around his 8-aisle department and straighten the aisle. So according to that employee, Mr. Lyerla, because the tile boxes were pretty heavy and 12 inches long, it would take effort for somebody to pull a box off the shelf, even if it was partially hanging over the edge. And he was not aware of an incident like this one where a product fell off the shelf and injured a customer, having occurred before in the Menards flooring department. Another employee, Adriana Steelman, who had worked for Menards, also testified she was not aware of any incidents where a customer was injured by a tile falling from the shelf. So the lawsuit was filed. Summary disposition was filed by Menards, arguing in relevant part that the plaintiff had failed to produce evidence that the hazardous condition existed or that the defendant had actual or constructive notice of the condition if it did exist. And the motion was denied, and then there was an appeal. So basically, what the Court of Appeals said here is in this case, there was no evidence to demonstrate that the defendant had knowledge, actual or constructive, of any hazardous condition. The plaintiff and her husband testified they didn't see any boxes hanging out from the shelves. They didn't see any safety concerns when they first approached the aisle. Somewhat similar to what the defendant said when she approached this, that she was not aware and she did not herself see that this was stacked improperly at first. The court in this Valdez case says that even looking in the light most favorable to the plaintiff and assuming that the boxes of tiles were protruding from the shelves and assuming that this was a hazardous condition, there was still no evidence regarding whether the condition arose or how long it had been present before the plaintiff arrived in the aisle. Hence, the plaintiff did not introduce evidence from which it could be inferred that the condition was of such a character or had existed for such a length of time that the defendant's employees should have knowledge of that condition. Furthermore, no evidence existed in the record from which we could infer that any of the defendant's employees had actual notice of the hazardous condition in the aisle. Nor is there any evidence that any defendant's employees negligently caused a hazardous condition. And so because there was no evidence that the defendant had actual or constructive knowledge of any dangerous condition, the trial court erred in denying the defendant's motion for summary disposition. The case was then reversed and remanded for the entry of the summary disposition in favor of the defendant Menards. We got the same thing going on here pretty much. What I don't have is any deposition testimony from anybody from Meyer, which the court had in the Valdez case. So there was some evidence to show what the employees did do, how they had stacked the shelves, what the shelves looked like from what the employees said. We don't even have that here. We don't even know if an employee even stacked these items. Like we did, though, at least that much in this Valdez case. So there was no depositions taken here. There's no interrogatories answered to even respond to any of that. There was no one in the aisle when this happened. The plaintiff says she didn't see anybody stacking these things improperly. We do know that the manager came over. The manager, from what the exhibits show, stacked the items facing the other direction, face down, with the handles up, like everything else was presented in the aisle. But that's after the fact. Similar to the Valdez case, the plaintiff in this instance has provided no evidence, actual or constructive, of any hazardous condition. But even if I give her the benefit of any doubts, assuming that these things were protruding in the way they were, with the heavy part up, handle down, and assuming that that was hazardous, even though there's nothing, no specific, information that it is, other than what the plaintiff claims she believes that it's hazardous. But even if you do not interrupt me, even if I make an assumption that this is constituting a hazardous condition, there's still no evidence regarding when the condition arose, how long it had been present before the plaintiff arrived in the aisle. She didn't introduce evidence that from which it could be inferred that it was of such a character or had existed for such a length of time that the defendant's employees should have had knowledge of it. We can't even infer that any of Meyer employees had notice of this condition in the aisle. And there's certainly no evidence that showed that Meyer employees negligently caused the condition. We have nothing that says who even caused that problem. So for the same reasons as stated based upon the law, and the reasons similarly stated in the Valdez versus Menard's case, this court is going to grant the motion for summary disposition in favor of Meyer, and that will conclude this matter. And do you have an order that you can submit electronically?
Yeah.
Yes, ma'am.
What is your finding on that? Because I'm out my pocket just as much as they.
Well, they're entitled to any court costs they might be out of. What else you looking for?
No, it would just be like the attorney fees and court costs for
Attorney fees.
for defending this matter.
Okay, well, what's the basis that you're looking for an attorney fee?
Just for defending this matter.
Yeah.
Well, you don't. Wait, just a minute now. Calm down. You don't get an attorney fee just for defending it. You have to have a basis for it.
Sure. I mean.
So you get your court costs.
What?
You get your court costs, but you got to have a court rule that tells me how, well, whether you have the money is not really germane
I
to.
got medical bills that I owe.
I understand.
Still can't pay them.
I understand.
I'm not paying.
So, but the bottom line is I got to have a court rule that says you're entitled to it and why you're entitled to it, not just for defending it. So, and I don't know what you're trying to say, but she was injured. This display was there. Just because she lost doesn't mean she has to pay the fee. So.
Take care of it. At the arbitration, they offered me $500.
Well, that's not really relevant. That's nuisance value, ma'am. They might have just said, go away. So we don't have to pay our lawyer to keep coming.
$1,000.
Well, maybe you should have taken that.
$1,100.
Well, now you don't have anything. I can't get involved in settlement negotiation. That is up to you two to decide. Okay.
So there was no negotiation with them.
All right. Well, so yeah. So no, unless you want to file a separate motion giving me some grounds as to why you believe you're entitled to some attorney fees here, that's going to be denied right now. So the motion though is granted. And you can have cost plus if you incurred some type of court costs or something. Other than that, you got to file a motion. So this is her brief. These are her photos.
Your Honor.
She'll prepare an order.
Hey.
We're done. We're done. No,
Bogus claims about me.
no, ma'am, no, we're not going there. Mm-mm.
They have the attorney agree
No,
with me.
no, you can do what you think you need to do, but we can't resolve all that here. Okay, so the motion is granted for the reasons stated on the record, and that's what the order should say, and the case is dismissed.
That without prejudice.
It's dismissed with prejudice.
On my medical records that they single if they have it. What about that? Okay, where's my document? Do I need to, where's my information?
First of all, I'm not the referee for your documents. You need to go out there and talk to counsel.
Where's my document? It's all.
Ma'am, that's not appropriate. You don't yell at counsel while court is in session. You don't yell at counsel when, okay. Well, then you're not gonna get what you're looking for. You're not gonna do that in front of me. I have more cases. I know you do. So, but you gotta go back out there and talk to her. Well, somebody from her office. If you're looking for something that you say they have, you gotta contact them. I don't get involved in that. Okay. Officer, would you please escort them out? How much more you gonna let them talk?
Sheila, Judge Johnson. Yeah, I don't get asked to leave places. I leave on my own. That's it.
You too. Okay, this is case number 2507509 GC Portfolio Recovery Associates versus Deanna Kegler. Is there anyone from Portfolio Recovery Associates present? And what is your name? Okay. All right, so this is supposedly the date for a motion to compel. So let's see what we're compelling. All right, looks like you went to mediation. Here's a motion. The motion to compel filed by the defendant, Ms. Kegler. You want to compel arbitration. All right. And this was a Citibank card agreement. All right. And so in your motion, you cite provisions of the Citibank card agreement, which is the debt that allegedly Portfolio has bought. And you say that the agreement states, and I'm trying to see, did you attach the agreement? I know you cited it.
And I also have it.
Okay. And you say that the agreement states that arbitration may be requested. This is page 5 of the agreement. At any time, even where there's pending lawsuit, unless a trial has begun or final judgment entered, neither you nor we have the right to waive the right to arbitration by filing or serving a complaint, answer, counterclaim, motion, or discovery. And it also says under page 6, the arbitration provision shall survive changes in the agreement and termination of the account or the relationship between you and us, including bankruptcy and any sale of your account or amounts owed to your account to another person or entity. And it talks in paragraph number 2 and references MCL 691.1682 that to choose arbitration, a party may file a motion to compel in a pending manner and commence arbitration by submitting the required forms and requisite filing fees to the AAA, American Arbitration Association. With the motion, the defendant requests the move to court to compel binding arbitration based upon this language. All right. I do not see any response. So your motion is granted. So what you're going to have to do is file an order granting your motion to compel arbitration, referring the case to arbitration through the American Arbitration Association, and then closing this matter. Okay, so you know how to draft something like that? All right, and then you'll submit it online like you've done. Yeah. Okay, you're all set.
Someone.
Thank you. You too.